In the last screencast, we talked about defamation, so this should finish off the last of the four parts of a libel suit, which is level of fault. This, until late 60s, early 1970s, plaintiffs only had to prove the first three: publication, identification, and defamation. And because we had a lot of investigative journalism going on in the 60s and 70s, the courts did not want it to be easy for corporations to stop that by threatening lawsuits. Because, even if you successfully defend against a libel case, you still kind of lost because you have to spend so much money on defending yourself. So filing lawsuits, or even the threat of filing lawsuits, could have been have a chilling effect on investigative reports, because in the process of gathering information, you're going to make mistakes. It's inevitable that at some point you're going to make a mistake that could be defamatory. And a lot of times your information is only as good as your sources. So the courts added this fourth part, level of fault. And there's two parts to this, negligence and reckless disregard. So let's go back up to the teeter-totter again here. And depending on where you are on this teeter-totter, a private citizen only has to prove negligence. That's an easier standard to prove. Public figure, a public official, courts want it more difficult for them to prevail in a defamation case, because we want to know what our public figures and public officials are doing. So they have to prove as their level of fault reckless disregard. Now, negligence uses a reasonable care standard to measure the negligence for private citizens. So in other words, would a reasonable person in the same or similar, would it be reasonable for a reasonable person in the same or similar circumstances to make the same mistake? If the answer is yes, then it's probably negligence. If the answer is no, a reasonable person in the same or similar circumstances would know to take greater care, then it would be negligence. And reckless disregard, sometimes also referred to as actual malice, is for public figures and public officials. And I've got down here, there are three types of public figures: involuntary, general purpose, and limited purpose. So let me go to another document to go through that. So public figures, how do you determine whether you're a public figure? Well, there are three categories. The smallest number are all-purpose public figures. These are people who are so well known that they can influence the outcome of anything. They're rock stars or sports stars or some kind of celebrity that you could use them for anything, whether it's a political position, a public interest position, selling a product, anything. But that's a very small group of people who are that influential. Then you have the involuntary public figures. These are people who are thrust into the limelight by circumstances beyond their control. Could be children of famous people or spouses of all-purpose public figures or public officials. Princess Diana, nobody heard of Diana Spencer until she became engaged to the prince. And then suddenly she's now an involuntary public figure, and eventually would become really, I think you could put her in the category of an all-purpose public figure. And then the largest category is limited. These are people who purposely put themselves in the public spotlight with the idea of influencing the outcome on some particular controversy. and they are a public figure only with respect to libelous statements about their position in the public eye, and the defamation must be limited to that reason for which they are in the spotlight. So courts use a two-step process to evaluate a plaintiff's status as far as being a public figure, and especially with limited public figures. So step number one is, does there exist a public controversy? And courts are very cautious, often defining a public controversy as something not that the public is interested in. Well, we're all interested in sex scandals, divorces, job dismissals, sexy, dramatic stuff, but rather something the public should be interested in, issues of more substantial nature and social impact. And then the second one is the plaintiff sufficiently involved in that public controversy? So these are some examples of people who have put themselves in the forefront to change the outcome of something. A scientist who wrote articles and gave speeches opposing fluoridation of water, attorney who initiated a recall campaign against city council members, an animal rights organization that had urged people not to buy fur coats, a newspaper publisher who regularly took positions on controversial issues, and a person who participated in a sit-in demonstration in front of an abortion clinic, for example. Public officials are those who are acting in positions, whether they were elected, whether they were hired, or whether they just volunteered, but they're in positions that impact the public. So here's some examples of professors and administrators at state universities, teachers, and community colleges, public institutions, teachers, principals, coaches in the public system, law enforcement officials, court clerks, tax assessors, and so on. These are people who can impact the public with being in the positions that they are. So this group, public figures, and this group, public officials, have to prove reckless disregard. And that's really tough because you have to prove somebody's mental state or their thinking process. So you have to prove a high degree of an awareness of probable falsity when they publish something that turned out to be both defamatory and untrue. So some signs of reckless disregard: did the defendant know the facts that would call the story into question, refuse to examine evidence that would prove or disprove a charge, rely on an inherently unbelievable source, publish an improbable story without investigation, or simply fabricate the story? So that's level of fault. Again, if you're a private citizen, you only have to prove negligence, which is an easier standard to prove. If you're a public official or a public figure suing a medium for defamation, it has to be reckless disregard. There was an interesting case one time where a newspaper was running a series on the legal system and what the problems, why it was breaking down. And out from this series of articles, this newspaper did an editorial on their editorial page. Well, an editor was looking at the layouts before it went to print, and he was reading the editorial, and he said, I just read the story, and the fact that this editorial refers to is different than the fact in the story. One of these two is wrong. So at this point, I think you can say that he has an awareness of probable falsity on the part of one of these two pieces of information. So he sends a reporter to the courthouse to double check. Now, I don't know what happened with that, but for whatever reason, the newspaper got published with the editorial without any changes, and it turned out that this editor was correct in that the information in the editorial was incorrect. And it was defamation. It would hold this person up to hatred, contempt, ridicule, or scorn if the readers believe this otherwise false information. And, if you're going to libel somebody, try not to libel a lawyer. And that's exactly who they defamed, was a lawyer. And the lawyer sued and won because, that old saying, no good deed goes unpunished. The fact that this editor sent a reporter to go double check the facts proved an awareness of probable falsity. And so he did not he didn't win the case. The editor lost the case on that because he published something that was defamatory. It was against the lawyer. The lawyer didn't even have to prove reckless disregard, I don't think, because he was more on a private citizen. Might have been a public figure, depending on the context of the story. But anyway, even if he had to prove reckless disregard, he did, because of this awareness of probable falsity. So I'm going to stop there, and then I'll do one more on the defenses. Even if a plaintiff that is suing you as a news medium has all four things in place, doesn't necessarily mean that you've lost the case yet.